The UCC Connection Claims Summary for Educational Review. 1. Scope and Provenance. You review a paraphrased seminar transcript circulated in 1990 and dated 1991 that presents a comprehensive narrative about uniform commercial code concepts, court practice, and governmental structure, and you are directed to treat its assertions as claims to be later analyzed. Footnote. You are noting the source's era and framing to contextualize the claims you will later test. 2. Central thesis about legal control. You are told that government power and courts operate as instruments of control, that lawyers emphasize procedure over law, and that you must learn rules to defend yourself without reliance on counsel. Footnote. You are highlighting the claim that institutional actors obscure the law and that self-study is essential. 3. Tactic on tax deficiency notices. You are instructed never to argue an assessed amount because disputing figures concedes jurisdiction, and you are urged to contest only the legal duty to file. Footnote. You are capturing the strategy that contesting facts waives the threshold challenge to obligation. 4. Public law versus public policy after 1938. You are told that a 1938 Supreme Court shift commonly associated with Erie reoriented federal adjudication from common law to public policy, rendering earlier decisions inapplicable to modern statutory enforcement. Footnote. You are summarizing the claim that a jurisprudential pivot in 1938 controls present outcomes. 5. Admiralty and statutory jurisdiction claims. You are told that modern courts secretly sit in admiralty and that jurisdiction requires a breached international contract, which you can demand be produced as evidence. Footnote. You are noting the assertion that compelled performance presupposes a maritime-style agreement. 6. National bankruptcy and creditor control. You are told that the nation is bankrupt, that creditors control all branches of government, and that judges privately acknowledge but never reveal this premise. Footnote. You are stating the claim that hidden insolvency explains court practice and outcomes. 7. Tripartite jurisdiction menu. You are taught that common law addresses injury to person or property, equity compels performance of contracts, and admiralty imposes criminal penalties for failure to perform contractual duties. Footnote. You are recording the framework used to classify seat belt rules, codes, and ordinances. 8. Colorable money and colorable contracts. You are told that gold and silver constitute money, that Federal Reserve notes are colorable instruments lacking substance, and that contracts using them become colorable and enforceable only in colorable courts. Footnote. You are reflecting the claim that fiat currency transforms jurisdiction and remedies. 9. UCC as governing code. You are told that the Uniform Commercial Code was adopted to manage colorable commerce nationwide and that courts enforce UCC-based obligations in lieu of common law. Footnote. You are noting the assertion that the UCC operationalizes a comprehensive commercial regime. 10. Reservation of rights under UCC 1308 and UCC 1103. You are instructed to sign documents without prejudice UCC 1308 to preserve common law rights and to invoke UCC 1103 to require harmony with common law unless clearly displaced. Footnote. You are capturing the claim that explicit reservations prevent waiver by estoppel. 11. Traffic court application. You are told to secure a court of record, place without prejudice language on identification, question jurisdiction, and insist on a complaining injured party before facts can be tried. Footnote. You are restating the procedural script promoted for contesting minor offenses. 12. IRS presentment and dishonor. You are told to treat a deficiency notice as a commercial presentment that can be dishonored with a rights reservation, leading to withdrawal of the assessment. Footnote. You are summarizing the claim that commercial paper rules defeat revenue claims. 13. Dual nation and federal zone theory. You are told that there are two United States entities, that federal statutes govern only federal territory and citizens thereof, and that zip codes and two-letter abbreviations evidence submission to federal regions. Footnote. You are noting the claim that domicile and address formatting determine jurisdiction. 14. Emergency governance and administrative detention. You are told that emergency measures would suspend constitutional rights, that detention facilities exist, and that disarmament and consolidation under international bodies would follow a formal bankruptcy declaration. Footnote. You are recording the claim that crisis administration supersedes ordinary law. 15. State accommodation to federal debt. You are told that states became accommodation parties to federal obligations through UCC-based dealings in Federal Reserve notes and that such commitments are unconscionable or no-interest contracts. Footnote. You are capturing the assertion that states can litigate to repudiate federal liabilities. 16. Litigation posture and courtroom dialogue. You are told to appear humble, profess non-understanding of the nature and cause, force the court to declare its jurisdiction, and threaten appeal if UCC provisions are ignored. Footnote. You are restating the tactic of leveraging the record to constrain the bench. 17. Social Security and assurance of performance. You are told to condition participation on a guarantee of constant purchasing power for future payments and to decline the contract if assurance is not provided. Footnote. You are noting the claim that commercial assurance rights permit refusal of enrollment. 18. Court reporting and transcripts. You are advised to secure an independent reporter to preserve a complete record and to deter off-record judicial remarks. Footnote. You are emphasizing the claim that the verbatim record is the key defensive tool. 19. Birth certificate and trust theory. You are told that your birth certificate operates as a bond establishing a trust, that you are the beneficiary rather than the trustee, and that surrendering the certificate discharges charges. Footnote. You are summarizing the claim that beneficiary status collapses prosecutorial standing. 20. Commercial crimes and administrative process. You are told that offenses are treated as commercial under administrative regulations and that UCC reservation is the universal remedy, though lower courts may resist until appeal. Footnote. You are noting the claim that regulatory definitions convert crimes into commercial disputes. 21. Affidavits and commercial maxims. You are told that truth is sovereign in commerce, that unrebutted affidavits stand as judgment, and that liens are satisfied only by rebuttal, jury resolution, or performance. Footnote. You are reflecting the claim that affidavit practice determines victory by default. 22. Historical development narrative. You are told that professional bodies and institutes advanced the UCC from the 1940s through mid-century, that adoption became nationwide, and that revenue enforcement was later tied to UCC-governed processes. Footnote. You are capturing the claim that institutional codification explains today's commercial enforcement.